Hello, this is David Waits and Teresa Thompson. Welcome to the webinar on protecting your company's reputation in the digital age. Before we get started, I just have a few housekeeping notes. One, for questions during presentation, if you want to submit questions, you can hover over the bottom of your screen to see the chat feature. Two, should the internet audio cut out, please use the dial-in number provided. And well, I think that's actually all we have for housekeeping notes, so I will turn it over to Teresa.
All right. Well, thank you so much for joining us today. We are here to talk about protecting your company's reputation in the digital age. And as David told you, you've got me, Teresa Thompson, and David Waits. And the two of us have actually been responding to a lot of questions lately regarding how to protect reputation online. And I have to say that this is a really broad topic. It's not just about review sites. It is about bad reviews, certainly, but it's also about employees who are harassing other employees online and make other employees think disfavorably about you. It's about employees who post client information or patient information online, and then people in the community wonder what you're doing in order to protect their client information. And it could just be employees who are engaging in kind of sketchy behavior online, and they're associated with you and make it known that they're employed by you, and then that comes back to you as an organization. So there are a lot of different things beyond just the typical review sites that David and I thought about when we put this presentation together. So we want you to think very broadly about these topics as we go forward here today. So what we are going to talk about here today is really about the fact that we are a connected workforce. We are all connected all the time, and that includes our employees. So when you're thinking about how to protect your reputation online, think about not just, I'm going to protect my reputation, I'm going to do something about this, but we also want you to think about how you can manage your liability relating to the employee use and posts on social media, and also think about whether or not your actions might implicate employee privacy while you're taking these particular actions. And so as we walked through this, we really thought about a lot of different things. So David is first going to start you out talking about Facebook posts, and you might wonder why we're still talking about Facebook posts, because it seems like it's kind of a passé thing. But we're seeing more posts on Facebook that implicate reputation. We're then going to talk about investigating and monitoring employee posts and what you shouldn't do, and thinking again about that liability. We'll then walk you through social media screening, if you're looking into what people are saying online before you hire them, or wondering what your employees are saying if somebody's screening you in that application and hiring process. David's going to walk you through avoiding phishing incidents, because this is particularly important these days and not quite about reputation, but he'll talk to you about how it fits in there. And then finally, I'll walk you through the glass door conundrum. And with that, I'll turn it over to David.
Thanks, Teresa. The first topic I'm going to talk about, I've called it, My Employees Said What on social media. Employees are humans. And as humans, they do stupid things. And inevitably, when they do those stupid things, they memorialize them on Facebook, Twitter, and other social media. And just as inevitably, you learn about those stupid things, whether it's from a customer or a coworker or otherwise. And those social media posts create significant reputational risk for your company. So when you learn about that employee who posted that inflammatory or offensive thing, the knee-jerk rational reaction is you want to fire that employee for the post. But as savvy employers, savvy lawyers, savvy HR professionals know, not all posts are created equal. Some posts can actually constitute protected conduct and can't form the basis for a termination. So the takeaway when we're talking about this topic is when you receive that inflammatory post or learn about it, think carefully when you approach a potential Facebook firing. This slide is just a small sample of the stories I found within the past 12 months regarding social media firing in the metro area, Minneapolis and St. Paul. It didn't take me long to find these headlines. A St. Paul cop who was placed on leave after encouraging people on Facebook to run over protesters. A legislative staffer who was fired after getting into a fight on Twitter. And just recently, some diner workers who a customer saw on Facebook posed in Nazi uniforms. They were fired. As Teresa said, this is not an issue that's going away. So when you see that offensive, inflammatory post, the first thing you need to think about is determine whether the post is protected. When we're talking about social media activity, the big source of protection is the National Labor Relations Act. Now, the NLRA, despite its name, applies to both union and non-union businesses. It's enforced by the NLRB, the National Labor Relations Board. So the NLRA gives broad protections for employees who want to talk about the terms and conditions of their employment. And classic examples of this include an employee's right to discuss his or her wages with other employees online, and an employee's right to criticize his or her supervisor. So these protections extend whether it's online or not, Facebook or in the workplace, doesn't matter. And because of these broad protections, the NLRB recently, or in the past few years anyway, has handed out some really stinging decisions to employers, reinstating employees who posted really vulgar things about their supervisors or their workplaces, used profanity. It didn't matter because they were talking about the terms of their conditions of their employment, even on Facebook in a public setting, that was protected and they had to be reinstated. So when you get that inflammatory post, do the analysis. Is the person grousing about a supervisor? Are they engaging in concerted activity with coworkers? Did any coworkers like their Facebook post or their Twitter tweet? Are they talking about a call to action akin to union organizing? Make sure the post isn't protected activity. Another large bucket of risk when we're thinking about social media activity is political speech. Employers run into these issues all the time, and this is an absolutely hot button issue for, I think, obvious reasons. So the question comes up, can you terminate someone for inflammatory political rhetoric? Now, one key misconception that I think a lot of people and employees have is the First Amendment. You can't fire me for political speech. I'm protected by the First Amendment. Well, not really. First Amendment in this context really only applies to public employers. So as long as you're not a public employer, it's not something you really need to worry about. However, some states have laws that limit your right as employers to take action based on political activity. Look at California. They have a law that prohibits controlling or directing or tending to control or directing the political activities or affiliations of employees. Could that extend to taking action against an employee for posting about politics, even in an offensive manner online? Potentially. Illinois is even more direct. They have a law that prohibits employers from keeping a record of an employee's political activities. So, excuse me, if you're going to take an action against an employee in Illinois, they might allege that you kept a record of their political activities by monitoring them online. What about Minnesota? We have a lot of Minnesota employers on the line here. To some extent, there's an obscure law that protects political activity, but it's really directed at running for office or campaigning. So, bottom line, although there are some misconceptions about the protection of the First Amendment, you still need to be careful when you're taking action regarding political speech. So you see the post. It's not protected activity of any kind. It's not protected political speech of any kind. The bottom line is you still need to treat this social media activity like any other disciplinary issue. Ask yourself the practical question. Is it important that I terminate now, or would a warning suffice? Should I grow a thicker skin and let it go? When an action is warranted, it's a good idea to step back and look at the larger context of the situation before acting, just like any other disciplinary issue, because you really don't want to make things worse by terminating. Now, you think about an inflammatory post, you might think, well, how would terminating make things worse? The reputational harm has already accrued. I want to talk briefly about the Streisand Effect. This is something you need to think about when you're taking action based on an employee's social media use. Now, this is the Wikipedia definition, so you know it's good. Streisand Effect refers to a phenomenon where an attempt to hide remove or censor a piece of information has the unintended consequence of publicizing the information more widely, and it's usually facilitated by the internet. So what specifically happened with the Streisand effect? A few years ago, there was a website called Pictopia.com. It had thousands of photos, including some of the California coast, and one which happened to have a picture of Barbara Streisand's home, which is seen on this slide. Now, Barbara sued to make Pictopia remove the picture. Before the suit, the picture had been downloaded 6 times. After the suit and news coverage, it was downloaded 420,000 times. How does this play out in our context? When you have a post and you terminate somebody for a tweet, a Facebook post, etc., you may be creating an interesting story. You may be creating a headline. Are you going to draw more attention to the issue by terminating the person and by potentially creating a lawsuit? That post that might have only reached 50 people might reach thousands of people. So when you're faced with a Facebook firing issue, consider growing a thicker skin and beware the Streisand effect.
And before we move on to investigating social media madness, I want to add one thing regarding Facebook, because this is something that we recently discovered that is a tool that you can place into your tool belt regarding how to respond to some of these Facebook posts. And one of the things that you can think about is if, for example, on Facebook, one of your employees is targeting another employee in some form, that employee is saying, hey, this is harassment. I don't want to work with this person anymore. They're targeting me on Facebook. I don't feel safe. What that employee can do, and what perhaps you can do if you have a Facebook account, is to contact Facebook and report that particular post and request that it be removed. What do you need to think about if you're going to do that? Well, what you need to know are the community standards on Facebook. And if you look hard enough in the help section, you'll be able to find the community standards. And they define certain things that they will address, and they'll actually remove or edit or disable accounts if appropriate. Some of those things are direct threats. Some of those are bullying and harassment. Some of those relate to protection of confidential, sensitive information, or, for example, the protection of an individual who might not be able to contact Facebook on behalf of themselves, like a patient. And if you make these reports and you outline why that particular post violates the community standards, Facebook will look at that post, they'll review it, and it's not a guarantee that it will be removed, but if you provide enough information and it fits within one of these guidelines, and you can certainly provide sufficient information to try to do that, Facebook will at least consider whether or not to remove that post. Now, there's a little Streisand effect in here, because when your disgruntled employee finds that their Facebook post has been removed, they may post about it again. But then their gripe is going to be toward Facebook, because Facebook removed their post, not you. So this is one way that you can actually address these unfavorable posts, again, if it falls within a violation of those community standards. So take a look at that, and remember in the future that you don't always have to fire. You can always take some alternative action. So with that, let's say you did get that, you get an anonymous post in your inbox, and it says, hey, I've just learned that one of your coworkers is posting disparaging comments about a client, about a product, about on Facebook or Twitter or somewhere else. And this is almost always how employers find out about disparaging, not necessarily because they're out there monitoring all of their employees' social media use, because that is nearly impossible to do, and probably not a great idea. Because if you're monitoring is going online, that you don't need from this standpoint. So let's just, for the sake of this example, that you receive this printout of the post. It arrives in your inbox, and the coworker is saying, we want you to do something with that. And you decide, well, I guess I need to investigate. And your decision is looking at, if I'm going to investigate, that must mean I need to monitor my employees' social media activity, other online activity, right? So you're going to go out and you're going to engage in this monitoring. So at that point in time, I just say, put that on pause and take a step back one more time and take into consideration a few things before you go out and engage that monitoring. First, think about whether or not the information that you've been provided is publicly available. What do I mean by publicly available? Most of the time, I think about that information that is online that you can get at without a password, without somebody else's assistance, without having to pay money. And so what does that mean? It might mean a social media post where there are no privacy settings. And so lots of employees still have no privacy settings on their social media accounts. It is flabbergasting to me, to tell you the truth, but nonetheless, many employees still have no privacy settings. Or, in my example, a coworker voluntarily provides a copy of the post to management. And this is important, voluntary. And it might also be a post, for example, that's read by a supervisor where the employee has friended that supervisor. Now, you have to be a little bit careful there, because supervisors really shouldn't be asking their employees to be friends on Facebook or in other places, because they might not feel that they have a choice. But nonetheless, some of the time, supervisors are friends, and they might be able to bring this information to you without having to ask for it. So those things are considered fair game. What's not considered fair game? If you have to use an employee's password to obtain information, that is not fair game. That means that even if that password is stored on your systems, maybe it's stored within, maybe they automatically populate their Gmail account, maybe they automatically populate their social media accounts because they leave them up and running all the time and you have access to their computer. Does that mean you should be getting access to those accounts? Maybe not. So if there's a password, think hard about that one. If you have to ask somebody else to gain access to the post, for example, if you have to go to a subordinate and say, I really want you to show me this, right at that point, that employee doesn't feel like they can say no to you. And there are cases out there that say that that's really a coercive type of access to that particular post. So think hard about that one. And never ever ask a job applicant or an employee to provide you with their social media login information. Many states have laws that prohibit you from doing that. And if you really think about it, that gets back to this concept of coercion, because an employee might feel that they can't say no. So think about where the information is stored. If it's public, maybe you have the right to look at it. If it's not, then don't. The next thing that you really need to make sure that you're doing is looking for electronic use policy. And why do I say that? Because the issue that we face with regard to looking at social media employees, for example, monitoring what's on your systems, is whether or not they have an expectation of privacy in those social media posts, even when they're gaining access to those social media sites on your systems. Now, I know that many of you have generic electronic monitoring policies that say, we are going to monitor all of your activity online. You don't have an expectation of privacy. This may include your email, your voicemail, etc. It might not say that it's going to monitor your social media activity. And you really want to make sure that your electronic monitoring policies are up to date if you face a situation where you decide monitoring is something you want to do. And you might question what I mean by monitoring. Now, there are a lot of different applications that permit you to see what your employees are doing. So, for example, I could call our help desk and I could say, hey, I need help with something, and then they could log into my computer and see what I'm doing live. Well, there are some other types of software that permit you to do that in a much less obvious manner. And it's in those instances where you really want to have a policy in place that gives you the right to do that kind of monitoring. And then, if you're going to do that kind of monitoring, make sure that you are really tailoring that particular monitoring as narrowly as possible. You do not want to be getting other information, possibly protected information, maybe really private information. Maybe they access their bank accounts and then you get access to their banking or their financial information. There's a lot of information that employees are accessing on a day-to-day basis on your systems. Even if your policy says this is not private, they can come back later and try to claim that it is. So the other thing to think about is not just that sort of really private, maybe financial information, but there might also be non-relevant personal information. Maybe you'll find out that the individual is disabled. Maybe you'll find out that they suffer from some sort of autoimmune disorder. Maybe you'll find out something that you then use or may rely upon or maybe can't get out of your head when you're making employment decisions later. So while we are not saying don't engage in this type of behavior, we do say be a little careful. And when you're careful, seek legal counsel if you've got any questions at all. And this is because employee privacy rights and monitoring laws vary from state to state and from country to country. And you really need to be aware of that because you could gain really important critical information. Maybe they're stealing information. Maybe they really are engaging in some sort of defamatory conduct online. But then later, maybe you won't be able to use that information because you've violated their privacy rights. And so as you go through this process to figure out how you're going to protect your reputation, make sure that you're not giving your employee a cause of action.
Who's walking through that door? We talked about what to do when things go wrong, but how can you use social media to screen job applicants? Or put another way, how can you actually be proactive in managing the reputational risk? Now, if you were all in the room with me, I'd ask you, do you use social media to check up on your applicants? Do you use social media to do a, quote, reference check? And some of you may raise your hands. Well, a recent survey shows that if you do use social media, you are part of the vast majority. 91% of employers admit to using social media to screen applicants via Facebook, LinkedIn, or Twitter. But just because you're using social media and you're part of that vast majority, it's not as easy to do it well. And if you're not careful about how you're doing the screening, you could create some liability. Now, personally, I think social media screening is a really great idea. While there is a risk, and we're going to talk about some of those risks, I think it's just a fantastic way to learn about applicants and manage your risk, to learn about the behaviors that create red flags that are going to cause problems down the road, and to avoid those before they lead to litigation or tricky terminations.
And just so you all know, David is the king of finding things online. He can find almost anything on anybody or anything.
And I don't know whether that's a good thing or not, but I do a lot of, quote, reference checks myself. So if you need help with that, feel free to call or email. But before I do anything like that, or before I encourage our employer clients to screen applicants, I want to talk a little bit about the risks. Here's the buckets of risks that you need to worry about. First of all, there's civil rights laws. I would put this under the rubric of TMI, too much information. What if you're screening an applicant and you learn they're pregnant or they use a wheelchair? Now, this might not form the basis for your decision not to hire the person, but if they look into it or start a lawsuit or file a charge of discrimination, they'll be able to point to the fact that you knew about that protected class status when you decided not to hire. State lawful consumable product laws, that's another bucket of risk. A lot of states, including Minnesota, have laws that protect an employee's right to consume lawful things outside of work hours. And so that would, normally normally cover things like tobacco or alcohol. So what if you do a Facebook check and you see somebody drinking a lot in their Facebook photos? Well, if that person's over 21, that activity is actually protected. A third bucket of risk is the Fair Credit Reporting Act and state equivalents. That comes into play if you hire a third party to do the social media monitoring. The FCRA and its equivalents in state law set out specific guidelines for when you can obtain information, how you can obtain information, and what you can do with that information. And then finally, Teresa talked about this briefly, social media password legislation. If you're actually asking your applicants to provide the passwords, don't do that. So those are the buckets of risks. Let's talk about how we avoid those screening problems. The first thing you want to think about is who is doing the screening. Are you doing it in-house or are you hiring a third party? Now, if you're doing it in-house, I think the best practice is to have a screener who is not the ultimate decision maker or supervisor of this eventual employee looking for the specific red flags. Train someone in HR who can filter out protected characteristics and advise that HR person not to report on protected things and things that aren't relevant to the screening. So if that HR person goes on Facebook and sees somebody that's pregnant or sees somebody that may be disabled, they're not going to report to the ultimate decision maker, and you can avoid potential discrimination claims. And of course, if you're not doing it in-house and you're doing it third party, make sure that third party is complying with the Fair Credit Reporting Act, which often includes obtaining consent and providing required notices when you decide to not hire somebody based on what you learned in that screening. Also think about, to avoid risk, what are you looking for? Look for both positive and negative information. Don't have the Facebook screening simply be a way to screen people out. But more importantly, ensure there's some job-related reason for doing the search. It can be something simple. You may be hiring for a customer service rep who needs to present a good public face to the company. So it's important that you see how they present their own public face. But maybe you don't need to do a social media check for a maintenance worker or somebody who's not going to be interfacing with customers or the public. So ensure there's some job-related reason. And at this point, I want to point out that this type of screening goes both ways. Not only are you screening your applicants are going to be screening you. So think about how your HR people, your recruiters, or your people who are going to be interviewing applicants present themselves publicly. I have a friend who interviewed or got an interview with a large company in Minnesota. He got the name of the person who was going to be interviewing them, and what did he do? He Googled them. And then he found their Twitter. And on this account, he learned two things. One, this HR person liked a certain political candidate, and two, they liked a certain type of wine. Now, I won't tell you which one was more important, but both of these pieces of information offended my friend, and he decided not to take the interview. So talk with your HR people, talk with your recruiters, and make sure that their public face is good and presenting the public image that you want your company to present. And finally, when you're thinking about what you're looking for, look for the same types of information for all applicants. If you've got one red flag you're looking for one applicant, make sure you're looking for the same red flag for everybody else.
And David, before you go on this one, I was trying to think about, like, what if you find the same type of information on a potential job applicant that your friend found? So something about their political affiliation or the type of wine that they like. Both of those things seem to fall, depending on where you are, in protected information. And so what would you do in that instance?
Well, I think you'd have to measure the risk that this person's the applicant is going to say after they don't get the job, it must have been that I like Merlot and I like President Candidate X, and not because I only had 4 years of job experience and not the 5 that they were looking for. So you measure the risk that a person's going to file a charge versus the benefit of not having somebody who likes the wrong type of wine.
And just one other thing I was thinking about, so because we're talking about reputational risk, what about employees who are out there bashing their current employer or a former employer? I'd probably want to know that if I was interviewing somebody. What do you think about that?
Yeah, I think that is probably the number one reason I would recommend clients, or what clients should look for, is sort of how they talk about their former employee, their employer, and their coworkers.
And I think that's important too. I really think about when thinking about reputation, and it doesn't go so much to whether they'll be a good employee, although it might be a good indicator, because if they're unhappy in their current job, there might be something that they'd be unhappy about with you as well. But if they are willing to go out and provide very negative public information about an employer, about coworkers, about supervisors, I think that that demonstrates sort of a judgment issue regarding that particular person, and you might be hiring somebody who could seriously impact your reputation at some later date. Something that we didn't really think about when we first started talking about social media screening, I don't think.
I agree. I think it's a question of judgment. That's definitely a business-related reason for most positions that you can use to justify social media searching. You can bet if they're posting certain things about their former employer, they're going to start posting things about you. Your customers may read that. So let's think about where and how you are searching. One thing to think about is what sites are you going to search? Do you absolutely need to check Facebook where people may have more photos or reveal more personal information, or is LinkedIn going to suffice? What are your search strategies and search terms? Are you being mindful? I often, when I search people, find mugshots or arrest records, and as many of you know, that type of criminal history cannot form the basis in most circumstances for an employment decision. So if you're using the right search strategies from the get-go, or using that HR screener to filter out that information, you'll avoid liability. And lastly, are you being consistent with where and how you are searching? Does every applicant have their Facebook photos looked at, or just one? You want to make sure you're treating everybody equally. And lastly, when are you searching? Are you searching every applicant after you receive the resume? Is it only after an interview? Only after a conditional job offer? I think the later in process that you do the social media screening, the less likely you're going to learn that protected class information, or that information that's going to be TMI that's going to get you into trouble. Because if you're searching everybody, most people are going to not make the cut, and you don't want to give them the ammunition or the reason to think that it was certain things that you learned in a Facebook screening that led to the employment decision. Now, we talked about this, but I think monitoring social media, and I'm sure there's lawyers who might disagree with me. I think it's a great idea, and I think you can do it right, and you can do it to minimize risk in a way that's going to protect your reputation before the harm comes through the door. Before we talk about Glassdoor, I want to switch gears a little bit. We've been talking about social media, but I want to talk about phishing and outside intrusions. Now, Teresa mentioned this a little bit. I don't think a lot of people often think about this as a real reputational harm. We all know that hacking or phishing can hurt your business's bottom line, but I really do think it has great risk to your reputation. And when people ask me about this, I tell them to think about Equifax. Now, a year ago, if you had asked me, do you care which one of the 3 big credit companies provides your credit score? I wouldn't care. I wouldn't care at all. But now, rightly or wrongly, I wouldn't want Equifax to be involved. I've read the news coverage. I've seen how they've been hacked, and I've used that to distinguish between those big 3 companies. Think about Target. Think about Yahoo. Hacking, phishing scams go public, they create headlines, and they have a potential to create serious reputational risk. So what are we talking about specifically when it comes to employees and employers? There was a recent story in the news about a Minnesota company. There was an accountant at this company who received an email from her CEO, and the CEO told her, "We're working on a big business deal. You should work only with me, only via email, and don't tell anybody about it." So they communicated via email for a few weeks. She helped him complete this business deal, and eventually he directed her to wire $50 million to various bank accounts across the world. There was just one problem. The person she was emailing with was not her CEO. It was somebody who had created an email account that looked exactly like the CEO's email account. It's called spoofing, and he stole $50 million from the company. So employees can be a conduit and are a conduit for these outside threats, but they can be your best defense as well to prevent the hacking, prevent the harm to your reputation. So what are best practices for preventing these outside intrusions? I think about it in terms of 2 big categories. One, you want to create a culture of confidentiality. What do I mean by that? Conduct frequent training. Highlight real-world threats. Hammer home with your employees every week, every month about the threat that this hacking, scams, and then finally, this is simple. Harden your systems. Review your vulnerabilities. Do an audit. Find out where your trade secrets are. Find out where your confidential information is and who has access to it. And work with IT and legal counsel to make sure that information is protected.
The thing I think that is really important on this one, and when David first talked about including this in the presentation, I was like, really, talk to me about why this is about reputation. But all of these things that we talk about with many of our clients about creating the culture of confidentiality, those are going to be the defenses that you have when somebody or the public or your shareholders come back and say, why didn't you do something better? And you can say, well, we did. This is what we did. This is what we did. This is what we did. And that gives you the ability to have a defense in the public eye. And that is really critical from a reputational standpoint these days. And certainly something that we weren't thinking about, even 4 or 5 years ago.
Yeah, I think under many laws, and especially for our healthcare clients or banking clients, when there is an intrusion and people access customer data, it might not actually harm your bottom line. They might not actually steal $50 million, but under the law, you're required to notify all those patients. You're required to notify all those customers. And the harm to your reputation, I don't think it can be overstated.
And it seems to me that when companies are not coming forward and being forthright about potential breaches, that also causes a harm to reputation. And that is definitely something that David didn't really highlight here and was far beyond the realm of what we're talking about here today. But if you're in that situation, make sure that you're consulting with a PR consultant as well, because really there are people out there that have specific expertise in how to manage the public image following this kind of a breach. So before we go on to the glass door conundrum, we do have a question, and I'm going to answer this in a couple of different ways. So the question is, do we have to disclose that we searched them, and that could be either an employee or an applicant, on Facebook? So the answer is, number one, probably not. So let's say it's an employee. You don't have to tell the employee that you are looking them up on Facebook. Somebody might tell them that you're looking them up on Facebook. Somebody might tell them that they've reported the post on Facebook. But ultimately, if you want to take employment action or disciplinary action based upon a particular post, then yes, you actually do need to tell them, because you need to be able to say, this is the basis for the action. And I suppose that you could say, well, they're at-will employees, and so therefore, I'm not going to tell them anything. Well, when you don't tell employees anything, then they believe that it's something else. And they're certainly not going to think it's because they did something wrong. And so I think honesty is often the best policy. Not all of the time, but if you're in that situation where you want to take termination action and you're not certain whether to disclose, then definitely seek legal counsel at that point.
For applicants, it's fairly unlikely that you'd ever have to disclose that that's the reason that you search people on Facebook at the time they apply or they interview. However, we have seen charges where people have filed charges of discrimination based on failure to hire, and it's possible that if the EEOC or a state human rights agency got involved, they might ask what strategies you used and what processes you used to decide not to hire the person. And then you would have to tell them that you had used Facebook.
All right, so moving on to the Glassdoor conundrum. And I am certain that many of you have been on Glassdoor. you have looked to see what your former employees and your employees are saying about your organization, and you've asked yourself, how can we get rid of those negative, awful reviews? So we're going to walk you through several different options for what you can do. Now, there are a lot of different online job site websites. Indeed and Glassdoor are probably the two that many see their reviews posted to. But if you run your company's name, you'll probably find a lot of other obscure ones out there where if a former employee is really looking to harm your reputation or make sure their negative review is heard, they will post it in every single place that they can find. And there are also different websites depending on your industry. And I noticed that we have a fair number of healthcare clients on the line here today. There are obviously Rate Your Doctor sites as well, where the doctor or the clinic can be rated by a patient. And so for medical clients, there's even a greater review process, should we say, because you've got patients in addition to employees to worry about. And we know that consumers, whether it's at a restaurant, whether it's rating your doctor, use these sites and rely upon these sites in order to make decisions, and so do your job applicants. And so that's why many of our clients are worried about the negative reviews that often they find to be false and damaging to their reputation. So really, what can you do? Number one, really think about who's posting on these particular sites. I mean, the fact of the matter is disgruntled employees are much more likely to post than your happy employees, but there are some things that you can do about that, and we'll talk about that a little bit. But let's walk through a hypothetical. So our hypothetical here is that a former employee is anonymously posting, and they're almost always anonymous posts. You'll very, very, very rarely find a name associated with it, except perhaps on Google. There is the potential to post on Google and have your name associated with it if you don't purposefully keep it out. But let's say they post false and misleading information about one of the managers on Glassdoor. The post talks about allegedly disrespectful treatment of employees, poor customer care, and faulty product features. Each of these things could impact your reputation in the public place. You investigate, you confirm that all of these statements are not true. But what are your options in taking care of this? You certainly can respond, and you have the right to respond, at least on Glassdoor and on many other websites, to any negative online post. Glassdoor.com does provide companies the opportunity to post their side of the story, particularly if you have an employer's account. And there is a reason to have an employer's account in some instances, and many of our clients have gotten that so that they have greater access to Glassdoor. But before you do that, and before you react to the particular post, it's much like David said with regard to Facebook and Facebook firings. Let's step back and think before you react. And I ask some of these questions because many of them relate to the community guidelines or the community standards or the posting standards on some of these review sites. Think about whether or not the post contains sensitive or confidential information. Is this trade secret information? Could information regarding your products, regarding your processes, be exposed and therefore have a greater impact on the profitability of your company? If so, then there might be legal action that you could take in order to have that information removed. And if it really is sensitive information, maybe it's patient information, then you have an obligation to respond and to react. Think also about whether or not the post is believable and will it really hurt your organization. This is back to David's concept of get a thicker skin. Some former employees are just going to gripe about their experience with your organization. And there isn't anything that you can do about it because it is their opinion. It is not necessarily false. It might be hurtful. It might be harmful. But a lot of employees that gripe like that, people in the public eye really take that with a grain of salt. Some applicants might say, gee, I don't want to work for an organization like that, but most applicants are going to dig a little bit deeper. So is it really going to be believable? And you really need to think about that one before you think about your next steps. Think also about whether the post violates any laws. For example, is there HIPAA-protected information? Is there a threat of harm to a particular person? As I noted with Facebook, if there is a threat of harm to a private person or entity, Facebook will seriously consider taking that down. Glassdoor is not as open to removing posts, but I have found that when the posts are threatening and really do think violent to a particular person or very threatening in a nonviolent way to a particular identifiable person, Glassdoor will be much more open to removing that post if you ask. The question that we always get from clients is whether or not this rises to the level of defamation. And I can tell you most of our clients believe that these are false statements of fact, that they are not opinion, that they will harm our reputation, and that they want to take action to have it removed. Unfortunately, it's not as easy as that. What we're finding with online posts is, number one, the websites themselves have absolute immunity. They cannot be held liable for the posts that are on their sites. So the websites themselves don't have a lot of interest or desire to take those posts down. You can sue the poster if you know who it is, and most often we do know who it is, or we can figure out who it is through a discovery process. But defamation claims are long fought, awful, hard battles. And sometimes you get to the end and you might win, and the jury might not award damages to either side. And this has happened time and again, both here in Minnesota and around the country. And so there's also the fear of the Streisand Effect. If you bring a lawsuit, you actually have to include the defamatory statements in your lawsuit. And so something that may have only been read by 6 people might be increased to hundreds of thousands of people, depending upon whether it's something that gets into the news or gets into the press. And I can tell you, if it gets into the Court of Appeals or into any kind of appellate court, then the statements are repeated over and over and over and over again.
And I think it's really important to note, because I think we've been getting so many calls and emailed concerns about Glassdoor specifically. One thing that we need to make absolutely clear, it's not just that they are not liable. They do not care. The way they pose it is, it's not our position. We're not in a position to determine whether something's false or not, whether it's defamatory or not. They do not care. They relish in the fact that they do not remove posts except in very rare circumstances. So Glassdoor is extremely reticent to remove things, and it's almost a non-starter to suggest to Glassdoor that something's defamatory and should be removed. That's not going to be enough for them.
So if you do, taking into consideration what David just said, if you do come across a post that contains sensitive confidential information, if it violates laws, if there is a threat of harm, if it is clearly abusive toward a particular individual, you can flag that post on Glassdoor. Now, David and I have not had a ton of luck with flagging posts. As David said, Glassdoor doesn't have really any incentive at that point to remove the post. You can escalate things and get to their legal department, and you might get a little bit more interaction and review. But if they conclude that the posts fall within the guidelines provided for posts and reviews, they will not be removed. And when David says that they relish in sort of fighting these things, he's really focusing on the fact that Glassdoor has actually been involved in some of these defamation claims where clients have attempted to unmask the anonymous posters, and Facebook has sided with the anonymous posters and tried to protect their reputation. And of course they do that because they want employees and former employees to continue to post. So, taking into consideration that legal options or a legal battle might not be your best option, what else can you do? And just for the record, we're not saying that you shouldn't try to have it removed if there is really a legitimate basis for doing that, because it can't hurt to ask. And certainly other websites are much more open to removing particular negative reviews, depending on the content, than some others. So do attempt to do that or contact legal counsel in order to try, because it certainly can't hurt. But let's say you've gone through all of those steps. Well, you haven't quite ignored the post, but your actions haven't done anything to get it removed. Let's say that it doesn't contain any confidential information, doesn't implicate any laws, is not violent or threatening. Then really you want to stop at that point and consider whether any response is warranted. Some of our clients do regularly respond to every single post on Indeed or on Glassdoor, and they've decided that that's what their company policy is going to be. And when a job applicant looks there or a former employee, they'll see that every single post will have a response. And they've decided that that's what their company culture is going to be. I think in some instances that's a good idea, and I think in some instances simply ignoring the post is the best course of action, because sometimes those employees or former employees are actually escalated by that type of conduct, and they may try to post in different places or anonymously post more. And while that violates the terms of use, it doesn't stop employees or former employees from doing that. The writing of a neutral response, as I said, is something that our clients have chosen to do. And again, the one thing that I caution is when you're writing that neutral response, really think about what your messaging is going to be to each of those negative reviews. And I think here is where you're sort of your own personal PR representative. And whoever is writing those reviews or those responses to the reviews should really be thinking about what is the broader statement we want to be saying about our company in response to these reviews. They should be consistent. They should be caring. They shouldn't be defensive. And some of those things are really hard to do when writing a neutral response, but it's important to consider because they're going to read your responses just as much as they will the negative review.
And I'd just add, I like the idea of if you're going to respond to negative posts, I think you should also respond to the positive ones as well. So I'd caution against just responding to negative posts because I think it can come off as defensive, whereas when somebody posts something positive and you say something simple like, thanks, or, we appreciate the good feedback, it just shows, and then you counter that with your response to the more negative posts. I think it just shows a better company face as opposed to when you're only engaging with the person when something's bad. It calls more attention to it.
Absolutely. So one thing we talk a lot about with our clients when we've walked through many of these different options, we've evaluated litigation, and that's really thinking about how to maintain a positive online image using social media. There are obviously a lot of different things that you can do outside the scope of Glassdoor or Indeed or Facebook or other places to maintain a positive online image. You can review your own website. When people look you up, the first thing that they should see is your website. And does your website demonstrate what the culture of your organization is? Do you have a Facebook or LinkedIn account that contains information regarding the human side of who you are as an organization and what you are as an organization? Those things are really positive because it demonstrates and people can visualize what it is like to work for you. Maybe you have even got like a little feed that goes through, this is what we're doing today, here's what we're doing. Because if I were a potential applicant, I'd want to be able to see what is the culture at a particular organization, and you can be in control of that if you choose to be. And I can tell you, many, many, many organizations are really good about talking about their products, their services, et cetera, and not so much who they are as an organization for their employees. And this can really have an impact on how you engage and recruit different applicants as well. Now, we've got on here that you could also consider asking employees to write reviews on Glassdoor. One thing you really need to be careful about here is that you really can't offer incentives, and you really can't push employees to write reviews for you. One, it actually violates the terms of use for Glassdoor if you're requiring employees to post. And two, if an employee leaves and is then a former employee, they're going to post on Glassdoor that the only good reviews are those reviews that employees are required to write. And that is not the messaging that you want to have. But there is certainly a way for you to try to have employees writing reviews and to encourage writing reviews without making it seem like you're pushing it. So again, think about how you can do that in a way to have writing reviews versus only those former employees. And again, when you're thinking about this, we've only listed a few of these things because we can't possibly, we're not PR people. We just see all of the ways that what applicants are looking for when they are looking for a job. But these are things that you have control over. And the reason that I say that is because you don't have control over those former employees, and there's not much that you might be able to do about them. But you are able to control your positive image.
And I think one thing to remember is that you are not alone. Glassdoor is probably one of the #1 hot button issues for a large set of our clients. And my view is that because Glassdoor is so problematic for so many employers, both good and bad employers, that people, applicants, and the public are going to start to take it with a grain of salt. And I'd analogize it to the website Yelp, which many people know used to review restaurants. 5-10 years ago, I used Yelp as the holy grail of determining where I was going to eat on a Saturday night. But Yelp has just been overrun by people posting negative things, people hammering on a business unrelated to actual experience, and Yelp is just really not reliable anymore. And I think because Glassdoor is so negative, even for the most positive, good workplaces, that I think a lot of applicants and employees are already starting to realize that you only go there to read the people that had a negative experience, and it's not an accurate reflection of what a workplace is like. So you're not alone. Glassdoor is a problem, but it's not something that's insurmountable, and that's going to be a huge hit to your reputation in all circumstances.
And one other thing to think about as we wrap up here, we've just got a couple of minutes, is in your recruiting process, if you have applicants that are actually asking you questions that seem to imply that they've read some of these negative reviews, have a good response. Be prepared to respond to those. And again, in that interview process, be prepared to not come off in a defensive manner, but rather have a very positive response that the applicant can take away and say, hey, I don't believe that review. So that brings us to the end of our hour. Thank you so much for taking the time to join us today. If you've got additional questions that we didn't get to today, please make sure that you reach out to us. We are happy to answer questions, and you can find us at our contact information, which is currently on your screen.
Thank you very much.